Emily, H-1B lottery has been done on 18th. Normally, we are supposed to get the results soon. I think so. There's something going on cooking up there. Based on some of the reports that I've heard, there are some fraudulent companies that have filed multiple H-1B applications, even if they don't, even if any of those employees are not working. What should the people who are genuinely waiting for their lottery system do if they know there are other fraudulent companies? So what should they do?
Yeah, because you know that every time someone else is submitting their name in the hat multiple times, that makes your genuine application less likely to get picked because you only have one entry and some people have 10 entries. So you do have some power to fix this problem, and that's by reporting this potential fraud to Department of Homeland Security. They have a special email address specifically for H-1B fraud and abuse. It's called report H-1B abuse at uscis.dhs.gov. And so if you know of someone who's got their name put in multiple times, you know that company, submit the company information so that we can weed out these companies that are ruining this process for everyone else, because it is a nicely efficient process, but it's got its problems. We have a lawsuit on this issue, which generated some positive change, but not enough. I think we're going to see that there's a massive amount of registrations submitted this year compared to last year and the year before.
So once you know that there is a company that has been filing for duplicate applications, or in other words, if the people are not employed with them, they don't have any genuine job opportunity, and if they have filed the H-1B and you know about it, it's better that you report it. And as I've learned that if somebody's, let's say for example, a particular person is working with ABC consulting company and they are working with Coca-Cola, let's say the end client is Coca-Cola though. Of course, when the ABC is filing an H-1B saying that you're going to work at Coca-Cola company, that's very genuine company. We like those companies, obviously. But if you have been contacted by multiple companies saying we're going to file H-1B, even if you don't have a job for us, with us, that is the companies that you need to complain though, even though you have not been through that company. It's worth for you to complain that this particular company has contacted you, even though they don't have a job opportunity, they want to file in the lottery, because you need to inform the USCIS. You can send it from an anonymous email if you want to, or you can list your name out. We don't see any adverse action on you if you complain though. This is absolutely needed. We need to avoid these fraudulent companies so that genuine companies can get a better job opportunity. We need to have, there are some people who are of the feeling that these Indian companies or Indian guys are fraudulent companies. We need to make sure that we eliminate this fraud. Just like the way, we have some fraudulent people calling from India, taking the money from the United States. That's very bad, a bad image on this. These 1 to 2% of the people will have a bad image of the entire Indian, and also on H-1Bs too. People will get a very bad impression on H-1B. So if you know about these companies, so I know some of these companies are operating from India, some of them operating from here. They operate with multiple names of the companies, and they keep filing multiple H-1Bs with the same employees. Please report these companies. It's definitely worth for you to report. We see a delay in the H-1Bs right now. Last year, when the H-1B lottery was over on Thursday, by about Saturday, we started getting the lottery picked up though. Now we have the lottery that was over on Friday, at about 12 Eastern time. As of now, we did not get it. We are hoping that the USCIS is looking into these duplicate applications though. If by any chance you fell into the victim of these companies of using your name to be filed, be careful. You may want to contact a lawyer. I have put a couple of links on how the fraud occurs in the H-1Bs. In the video, I put a couple of links there. And normally, if you are one of the applicant that have chosen this particular fraudulent company though, it's going to haunt you. You may be permanently barred to come into the United States. We started seeing from February or January of 2022, some of the people who filed with 5 or 6 different companies in the lottery system, they are hit with a material misrepresentation because you have given your name to these particular employees, and the employees have used to apply in the lottery to abuse the lottery system. It's trying to obtain the immigration benefits by using fraudulent means is a permanent bar for you to ever come into United States, to ever get a visa, and you will be turned back. So if you are one of those people who have used these companies, it is definitely worth for you to contact an immigration lawyer though. What are the signs do you see about these fraudulent companies?
Yeah, I think a big one is they don't have an actual office address. They're operating out of a PO box, basically.
Regus kind of thing, yeah, shared office space.
Yeah, and they're offering. If it sounds too good to be true, it probably is. They're offering to go through this lottery process on behalf of someone that they have no interaction with, no idea what your skills are, no background, no knowledge of you, no personal knowledge of you. If you don't have any kind of connection with this company, then those are some of the warning signs. Do you have any other ones?
Yes, Emily. One of the things is that it's a consulting company, and they file a H-1B, but they have never had interview with the end client. Normally, when consulting companies place individuals at the end client, let's say, for example, when the ABC company placed at the end client with, let's say, Coca-Cola, though, the vendor and also Coca-Cola company interviews this particular individual before they place. When these people are filing the H-1B, there's no interview done, nothing has happened. That's definitely a big sign of it. Also, when you look into the profile of them in myvisajobs.com, you can see they don't have lengthy history though. They've been recently formed, and the kind of H-1Bs they file, you can take a guess of it though. Myvisajobs.com, that's one of the other things that I normally go and check what kind of company this is, when this company has been formed, and how many H-1Bs these people are filing. As you said, if they don't have any office space, that's definitely an indication. If they are operating from a residential address, that's even a big indication that these people are fraudulent companies. So if you have filed your name, it's better to take your name off and complain against these companies though, because they have lured you into these things, and it's time to complain against them so that at least you will be saved. At a later date, when USCIS or when the Department of State in the consulate, you get hit with the misrepresentation, you can defend it yourself, saying that you are being lured into it and you made your rectification as soon as possible by complaining, and we have given the email address where you can complain against these companies. Anything else, Emily, before we move to the next topic?
Nope, I think we can move on.
Emily, Stephen Brown from our office is pointing out that processing time of the EAD is 14 months to 17 months in Texas Service Center and so on and so forth in Nebraska though. What's the solution? Because especially on the adjustment of status EAD, they tell us not to file more than 6 months, and you can work up to 6 months over and above the EAD. And if it's coming very near to the time where my EAD is expiring, what is the solution there?
Right, because you can't do a service request because their processing time, that date they give you for a service
request,
I
don't even believe your service
2 years ago. So that's shut down. The ombudsman really doesn't do anything because it's within the normal processing time. Your congressman and senator won't do anything because it's within the normal processing time. So one option you have is to request an expedite of the EAD. This works best if you're a healthcare worker under the recent policy guidance on that, which created kind of an expedite procedure for healthcare workers. But not everybody fits into that category. There's other categories for expedite. A lot of them are not used by USCIS, like financial hardship.
According
you tell them you're going to lose your job and
they don't worry about it.
They don't care. So the expedite is not a great option. Beyond that, I think the best thing we have found that has been working is litigation. We've talked in the past that, well, why don't you litigate the green card delay? Just get us the green card. Don't worry about the EAD.
That would have been the best solution, obviously.
Yeah. The problem with that is the courts will strike that down on jurisdictional grounds, saying we don't have the power to compel the government to approve your green card because it's discretionary that they do it under the statute. There's no deadline for it. That's not the same for the EAD and AP process. So if the EAD and AP have been pending for 6 months, when we file a lawsuit, we have been getting results. We're filing it under the Administrative Procedures Act, which allows you to file a lawsuit against any government agency when they are unreasonably delaying the processing of whatever it is you've submitted to them. And here, these delays beyond 6 months are clearly unreasonable because the government said, we're going to extend your EAD automatically for 6 months to give us enough time to approve it. Well, if you file 6 months in advance and they extend it 6 months beyond, they can't even get it done in a year. Clearly, that's unreasonable. So we have been seeing success with that. So if you're in that situation where your EAD AP has been pending for 6 months and you're at risk of losing your employment authorization, I would suggest reaching out to our office, especially Stephen Brown. He can guide you on whether litigation might be right for you on that.
Emily, Stephen Brown, wow. Let's speak about his other litigation that he did on the class action suit on the EAD delays. EAD and L2 delays. He's one of the attorney for the class action suit. And now, pursuant to the settlement though, what is the update on the L2 EAD assembly? What they are telling right now is that L2s do not have to file an EAD right now. But what if, and when people are entering into United States on a L2 I-94, the CBP grants them not only I-94, they give some permission for them to be used as a substitute for the EAD, and that means they can start working. They don't need to file an EAD. That's a very good, thanks to our Stephen Brown though. Now for those people who are getting approval of the H-1B, H-1Bs after, starting from February 1st of 2022 though, the spouses are getting the EADs, the EAD is already marked in there so they can start work. Now what about those people though that have entered United States before on CBP? That means that they entered through the airport or through the land, through the border, they got the L2 stamped in their home country and came in. They are telling to contact the CBP, that is Customs Border Protection Unit. You can go to their office and they are going to endorse the I-94, thus by you can continue working. For those people whose H-1B has, L2 has been approved in United States, their I-539, that means that their L2 has been extended and their I-94 is not endorsed with that, what they're telling is that the USCIS is going to contact them starting from April 1st of 2022. Is that a better solution, that you wait for the USCIS to contact and then give them the H1 approval? Is there any better solution though?
Yeah, knowing how USCIS operates, we have no way of knowing what address they're going to send these letters to. You may have filed your I-539 2 or 3 years ago and they're going to be sending it to an old address. So we don't know how long this is going to take. They claim it's going to start April 1st, and that if you don't get it by April 30th, then you can contact them to follow up. Well, how long is that follow-up process going to take? You know, we have very bad impression of USCIS these days with their ability to efficiently handle these things. So you may want to consider instead traveling using automatic revalidation, or the Margarita switch that we talk about, where you can travel to Canada or Mexico for less than 30 days, even if your visa stamp is expired, and you can show that L2 approval that you got from USCIS at the border when you're coming back in by air, and CBP will give you a new I-94 that has the little S notation on it that says that is what shows you can work. So that would be another option if you don't want to wait around for USCIS to send out these letters. Who knows where they're going to end up.
Emily, so for the people who entered into United States through the CBP, Customs and Border Protection, the best thing is to contact the CBP. They're pretty much open, they're entertaining people, and they're granting the I-94, which is very good. So for the people who USCIS has approved the extension, you're telling that the Margarita switch is the best thing. Instead of waiting for the USCIS to give, they just go to Mexico. And you said even if the passport visa of the L2 is expired, they can still go and come back on the I-94 through automatic revalidation. That's an easy thing. Just go to Mexico and have a margarita. And don't forget to enjoy. Mexico has very good beaches, guys. I do endorse Cancun beaches and some of the beaches that are very good. You can go and have a nice margarita and come back though. That's a better way, or you can wait for the USCIS to send the notice for you with the I-94. God knows how much time they're going to take. But you can try to do that, or you can do the margaritas, which you choose your option on that thing. Emily, on the I-485, this has been a nightmare now. It's getting stuck in Texas Service Center. The people who filed in October of 2020 does not get the biometrics, does not get the EAD, does not get the advanced parole. Then we have people who have filed adjustment of status after October that ended up in National Benefit Center that get their EAD and advanced parole denied, but their green card got approved. And a lot of times, if you're filing an I-140 right now because your perm got approved right now though, what we're telling people is that wait, don't file the 485 yet. File the I-140 in premium processing, get the I-140 approval in premium processing, and once you get the I-140 approved though, then you file the 485 though. Now that's completely contrary to what we have told them in October of 2020, because at that point of time we didn't know how the things will work out. In most of the cases we filed in October 2020, we filed the downgrade cases where premium processing is not that easily available. But for the people, even if you are the rest of the world, or even if you are Indian national people, if you're filing an I-140, get the I-140 approval first. Now, obviously, if you're refiling an I-140 based on your previous I-140 approval using the old labor certification, you may not want to use this trick though. But if you just perm got approved within 6 months, you're filing the, you're planning to file the 485. First, get the I-140 approval, because if you don't, if you file I-140 from 485, you will end up in one black hole, which is Texas Service Center, or another black hole, which is Nebraska Service Center. But if you file a standalone 485 application though, then you have a very good chance that you will end up with National Benefit Center, which is very fast. If you look into the statistics given by the USCIS, there are 90,000 plus cases pending in each of those service centers, which is National Benefit Center, Nebraska, and also Texas Service Center though. Guess what happened? In National Benefit Center, 30,000 of those things were approved in the first quarter of this fiscal year. Guess what happened in Nebraska? Out of the 90,000, only 3,000 gets approved. Guess what happened in Texas? Out of the 90,000, only 3,000 gets approved. Now you pick the poison what you want. It may be a better strategy to file an I-140, get the approval, and then file the 485. Then comes the question of, I file my I-140, it still doesn't get approved, and my priority date moves back in May. What do I do?
Yeah, in that situation, you can still file the 485 based on the receipt notice of the I-140 so that you don't miss the boat on the priority dates and retrogression happening. So at least trying to file the I-140 in premium first and seeing if you have the time to get it approved, you have that option. And then if dates are going to go backwards, 15 days in advance before that's going to happen. So you have enough time generally to be able to still submit that 485. Downside is it's going to go to the service center that your I-140 is pending, which is either Texas or Nebraska, but at least you won't miss the boat on filing your 485.
Emily, I have some questions that I'm getting recently from my daily conference call, Emily. I filed my 485, it ended up in Texas Service Center. My final action date is current in EB3 and my I-140 is approved. Can I refile the entire 485 again right now?
Yeah, I've been getting that question a lot. And this is the situation where you want to refile like a duplicate 485 based on the exact same I-140, not a situation where you downgraded before and now you're trying to upgrade.
Let's say mine is just straight EB3, but I still ended up in Texas Service Center. Can I still refile the entire thing under EB3?
Yeah.
Is it legal?
I don't think there's anything specifically prohibiting it. There's definitely nothing that says you can only file one 485. Obviously, we've been doing refiles in other situations for quite some time. The issue is, have we done that where we filed a second 485, the exact same thing? The only times I do that is when something I know has gone wrong with the first one and I can correct it by quickly filing a second one, because I know the first one is either going to get denied or it's going to get rejected for some crazy reason.
But that's not the purpose, Emily, that I've been in this country for 10 years. I know that if I don't get the green card by October 2023, which is 1.5 years from now, I may be locked up in this state for the next 20 years. What do you say?
Yeah. Again, I haven't tried it. I'm considering trying it. I definitely have people asking.
Yeah. Is it illegal? Definitely it's not illegal to file it, but you need to evaluate if it's going to work, if it's not going to work, and the expenditure that is involved in. We don't see any harm, but definitely money is an aspect that comes into it. And whether your company is going to cooperate for that or not is also one thing that you need to look into. Humus has this question we're going to go to question and answer. Humus from YouTube asks, does Margarita Trip needs a Mexican visa, assuming that US visa is not stamped on passport? If you do not have an advance parole to come back into the United States, if you're doing for other purposes though, yeah, you may need a Mexican visa to go to places though. But if you have an advance parole or if you already have a stamping, then you don't need a Mexican visa, but otherwise you may need. I'm looking for any good travel agents that will support our things. So if you use any of the travel agents to get the visas faster, please recommend us so that we will put it out to other people. We haven't got very good travel agents that we can rely on. So if you get somebody, please let us know whether things can be worked out much faster.
Momo wants to know, what are the chances and reasons of an I-485 denial for the employment-based category? The number one reason is the I-140 denial. So this is the situation where I-140 and 485 are filed concurrently, and for whatever reason the I-140 gets denied. Maybe ability to pay problem, maybe a problem with experience letters or something like that, or the wrong category, EB2 versus EB3. That's the number one reason. Beyond that, they're looking at grounds of inadmissibility. Is there something that in the law does not allow you to adjust your status, such as not being in status at the time of filing the 485 application, criminal issues, health issues, those are terrorist types of things. Those are the main issues that they look at in the 485 filing. And of course, verifying that you do have a legitimate job offer.
Smriti has this question from YouTube. Should EB3 I-140 be approved before they take the decision on the refiled EB2 I-485, which is at National Benefit Center? Absolutely, it's not required for EB3 to be approved if you refile the entire application. Absolutely not needed. Even if the EB3 is pending, if you refile, you can get the EB2 green card approved. Question from Rods from YouTube. It's regarding H-1B. How do I know if I'm allowed to work 2 jobs? Was there something mentioned in the I-797 document or on the I-129? It is going to be on the I-129 document though. In the I-129 document, there is a question that has been asked. Is this an H-1B extension? Is it an amendment? Is it an amendment? Is it a transfer from one company, or is it a change of status? Or is it just a concurrently filed H-1B? That means that you're going to be working for 2 companies. It clearly asks for concurrently filed H-1B. So that is a mark on the I-129 that will determine whether you can work for 2 jobs. On the I-797 itself, there is nothing there that you can read.
Sri says, I had an EB2 I-140 approved from an employer, and that was withdrawn after a year because I moved to a different company. Can that first company apply for that I-140 again and file adjustment of status, or do I need to start from the labor again? So if the first company is offering you, again, the same job that your labor was filed for in the same work location, same job duties, same salary, everything is the same, they actually can file a second I-140 using the old labor certification to kind of reactivate the withdrawn I-140, and then you can file the adjustment of status based on that.
MK has this question. Please explain pros and cons of joining a company on H-1B as a managerial level resource, which promises to hire and send the resource to their Indian branch and get them back to US, file the GC on EB1. These are good, but when it comes to practicality, there are a lot of difficulties in getting an EB1C though. The EB1C has a very high denial rating, especially if the company is sending the individual back to the home country and bringing them back here though. The possibilities of approval are very less though. You need to look into, normally I tell people that you must be supervising 15 employees at least there, 15 employees at least here. Now, that doesn't mean that if you are supervising 15 employees, you're guaranteed to get it though, but at least you have a fighting chance to get it though. And like, for example, our law office has an accountant. Practically, the accountant supervises all our accounting things in our office. We may have 50 people or 60 people in our office. She supervises, she's in charge for all the people in accounting. But is she really in control of all the 50 people, including Emily and me? No, our operation is different. We are not assistant accountants though. So she's functioning independently. Those things are very, very tough to get those things approved. If somebody is there underneath the person though, it's more easier. For example, Emily is the boss of the office, and if she is, and I also report to her, there are a lot of other people that are, yeah, she may be easily qualified for L1A, but when it comes to the accountant, which actually supervises all the accounting duties, she may not be qualified for the EB1. That's a simple way. So when you are making that big move of going to India, spending 1 year there and then coming back here, you may want to evaluate yourself, consult a lawyer, look into what position you will be hired there, what position you will be hired here, and see what are the probabilities now. Don't ask an immigration lawyer or any lawyer, is it possible? That's a question people ask the question. Is it possible? It is possible. I mean, everything is possible. You need to look into what are the probabilities of success. What are the probabilities of success is the main important thing that you need to ask. It is possible, but the possibilities might be way, way less. It is good to have an evaluation done before you make that big move.
Premnath filed a downgrade application in 2020, and that was done as an amendment because the company was acquired by a different company. He's since received the EAD and AP and has used those, so he's married to this EB3 485. He wants to know if he can amend the EB2 again and interfile concurrently. Yes, that is an option if your employer is willing. So the reason that you have to amend that EB2 I-140 is because there was still a corporate change structure that happened, and so that EB2 I-140 has now been replaced by the EB3 I-140 because that was filed as an amendment. You can re-amend that EB2 I-140 using the same labor certification, showing the successor in interest, and then once you have that receipt notice, you can do the interfiling with your existing 485 into EB2 based on the pending I-140 amendment.
Casey, can we fly and do Margarita switch in 1 day and need to stay in Canada or Mexico for more than 1 day? There are some cases where people have gone and came back the same day that were being successful. There are some officers who said that there must be a meaningful trip. If not, we are going to let you allowed to come back on the same I-94 that you got in. So that's the reason where we strongly recommend to stay 1 day. But there are some cases that people have gone and came back. So it all depends on the officer.
Raul says, can the derivative applicant continue to use the 485 EAD after the primary applicant moves from AOS back to H-1B? Yes, so since the H-1 holder is the primary applicant, if the derivative uses the EAD, it has no impact on the primary, and the primary can switch to H-1B while the derivative stays in adjustment of status using that EAD.
Abhiram has this question. My old employer says they sent the request for withdrawal for I-140 6 months back, but when I requested the FOIA, USCIS sent the I-140 still shows approved. How long it takes for the withdrawal? Any possibility of filing I-485 with that I-140? Now, once the employer has sent the I-140 approval though, I will never file 485 on that one, because they may take all my money, of course not my money, your money, and then after 2 years they're going to say, oops, something went wrong, your I-140 has been withdrawn. Now guess what, you lose all the filing fees that you paid, and guess what, the money that you paid me is gone too. the better solution for you, Abhiram, probably would be to file an I-140 again and file the 485. Even though it's been withdrawn, your company can file an I-140 again using the old labor certification. Absolutely not a problem. You can do so. Ashwin Patel has this question from YouTube. EB2 I-140 approved, priority date is February 2015 with employer A. Now I got a job offer with employer B. Do you recommend changing the job, especially the date has moved so fast for EB2? Lubduck, September 2014. And it moved almost 1 year in the month of April 2022. Lubduck, what's going to be in May? I am not moving, Ashwin. Come on. You are just 5 months shorter. I am not moving. I'm not going to tell you what to do. Believe me, I've gone wrong so many times. I will wait for 2-3 months before I can make any decision, or the USCIS will probably indicate, hey, now we are not going to move the dates. If they give an indication, that's fine, but I'm not moving if I'm just 5 months away.
Casey says, when the H-4 EAD extension is filed, if we go out of the country to Canada or Mexico and come back, they're not voided, but if we go to India and come back, they will be. Is that true? No, it's not true. An extension of stay is not abandoned by travel. A change of status is. And the rule used to be that both a change and an extension would be voided if you travel. That's not the case anymore. So if you were in the US at the time of filing and then you travel, you can, that H-4 and EAD will continue to be pending. The issues that come up are when you come back in, your I-94 number is going to change, and you want to get that new I-94 number on your I-539, and especially if you got the extended I-94 when you re-entered, you want to send that to your EAD application so that they can, don't worry about the I-539 anymore, I already got my extension, please adjudicate the EAD now based on the fact that I have this extended I-94.
Can we file I-485 ourselves without a lawyer? My suggestion is don't. When I taken the bar exam, and when I was supposed to file the 485, my wife said, why don't you file the 485 for me and her? I said, no, let's go with your employer's lawyer. Definitely, I did a good choice. His name is Samuel Batista. He's my lawyer from New York. I have no problem, completed all the paperwork, got it. That's what I did. That's what I would suggest you to do too. Kish has this question. Can I interfile from EB3 to EB2 if the priority date is in the filing chart? Yes, you can interfile though. That's something that, Emily, that previously I told people that technically you can. When the filing date is current, can you interfile from EB3 to EB2? The answer is yes. Would you recommend to file? Previously I was telling, no, I would wait for the final action date to become current because we're telling the officer, hey, give me the green card, and they can't give the green card because the final action date is not current. But I'm kind of in a second mode right now. They're taking 3 months, 2.5 months, 3 months to issue a receipt notice. Is it worth to do the interfiling when only filing date is current? I'm kind of changing. My only issue is, what if the EB3 moves forward then? That's it's kind of, you have to make a decision, because if the filing date is current, you file the interfiling and say EB2 move, give me under EB2, and the USCIS will take its own 6 months, 1 year, I don't know how much time they're going to take, and then guess what? What if your EB3 moves forward and then EB2 moves back? That's a problem. There's another problem is that, which is an advantage for you to file it right now in the filing chat, is that because they're taking a long time though. So if you file right now, maybe by the time they look into your application, your final action date is current. So there's an advantage, there's a disadvantage. So your option to pick which one it is.
Sumit has an EB1C adjustment of status pending since 7 months with an approved I-140 and wants to know, based on the current trends, how long might it take to receive the green card? I think part of it depends on where your 485 is pending, and was your I-140 and 485 filed concurrently. My recent cases, I had one that took almost 2 years to get approved, even though the priority date was current the entire time. The I-140 did take a little longer than normal to get approved, but yours has already been approved. So it does not look good. They're definitely taking their sweet time on those as well.
Siddharth Goyal has, my wife has changed from H4 to H1 change of status. Is she eligible for Dropbox processing with the visa stamping in India? Absolutely. She is eligible for the Dropbox. There is an exemption until December 31st of 2022 that she can go for the Dropbox. Here comes the million-dollar question for me. So many times it's coming up right now. The I-693 form, which is used for the medicals to file the 485, is expiring on March 31st, 2022. If I get this thing signed and I have to file my application only after April 1st, can I still file using the form that is expiring on 3/31/2022? Absolutely, you can file. It is perfectly all right to file the 485 in April using that form. They do that expiration date until the new form comes in, and sometimes the new form may come in 2024, even though it says that it's expiring 3/31/2022. As long as you go to the website of the USCIS and you look into the expiration date of 3/31/2022, even if you're filing in April of 2022 or April of 2023, you can still use it as long as the website one says the same thing. Right now, the website says 3/31/2022. There will not be any change until April. Even if there is any change, they give a certain duration of time that they will give for the first 2 months. You can use the old one. Right now, guys, for those people who are filing in April of 2022, even if it expires on March 31st, 2022, 693 form, you can file using that one. Absolutely no problem.
Barath from Facebook says, I have 4 months for my H-1B max out time. My perm is approved and getting ready to file the I-140, but my perm filing date is after the start of my 6th year of H-1B. Can I file for the H-1B extension once my I-140 is approved, or do I have to wait until 365 days from my perm filing date? I don't have any recapture days. So assuming that your priority date is not current, you need to get your I-140 approved immediately, get it done in premium processing, and then you'll be eligible for 3-year extension of your H-1B, even though your perm was filed in your 6th year. If your final action date is current, there's no option to extend until you hit the 365-day mark. It's one or the other. So that would be the big question, is what is your priority date? Are you porting an earlier priority date that's going to be current, or is this a fresh perm, never filed before, to where your priority date is very recent?
Durga has, I have EB2 approved, I-140 priority date, July 2013 with employer A, now working with employer B, perm certified, and I-140 will be filed in EB3. Because the job requirement is EB3, can I now move to EB2? Not with employer B. That's the reason when even the priority date was way advanced in EB3 than EB2, we always advise people to file the perm if they are eligible to only file in EB2, because the EB2 perm can be filed EB3 or EB2, but EB3 form cannot be filed under EB2. One option that I would suggest you is that your old employer is a very good employer, Mr. Durga. Why don't you just go back to the old employer? That's one solution that I have. The second solution I have is that have company B file one more perm application under EB2. That's another solution. The third solution is you may contemplate changing the jobs, because the priority dates are at this point of time January of 2012, and your company from the beginning didn't show any flexibility. That's the reason they put you under EB3. They didn't care about you. You are just one of the number for them, according to me. So that's another reason you may want to consider leaving that company. Abdul has this question or suggestion, or is saying that it seems that there has been a flurry of employment-based cases, mostly filed in October 2000, have moved to NBC in the past week. Is it a good news? You are right, Mr. Sheikh. We have noticed that. I've noticed those cases moving to NBC. Obviously, definitely, if my case is moved into from Texas or Nebraska to National Benefit Center, that's a very good news. Because if you look into the stats of the first quarter of 2022 fiscal year, which ended on December 31st, from October 1st to December, NBC, National Benefit Center, approved 30,000 plus cases, though, while our dear Texas Service Center, Nebraska Service Center only approved 6,000 cases, both service centers combined. So obviously, if my case is moved into National Benefit Center, yes, that is a good news. Now, please don't pay us the money. Hey, Rahul, can you move my case? Can you help move my case from Texas to Texas or Nebraska to National Benefits? There is nothing we can do for it, guys. Please, we cannot do anything. It's just they move it. It's their internal thing. We haven't done anything, and we can't do anything either.
Sarisha has an H-4 EAD due to expire in September and wants to know, after her spouse's H-1 extension, in order to use the 180-day automatic H-4 EAD extension, what do you suggest? So yeah, great idea to get the spouse's H-1B extension approved first, and then before your current H-4 expires, but after your spouse's H-1 extension is approved, you can travel to Mexico or Canada using the Margarita switch, stay there for the weekend, have a margarita, come back by air, show your husband's H-1B extension approval notice along with your H-4 stamp, and you should get a new I-94 that's valid till your husband's new H-1B expires. Now you have an extended H-4. Come back in, file the EAD, and then you get the automatic 180-day extension. That's option one. Option two is to file all of the applications, H1, H4, and H4 EAD all together. And then if you don't feel like it's going to come through in time, still do the same thing, but you've already got your EAD pending at that point.
Kishore is asking that he is an EBC concurrently filed in 2021 and completely stalled at Texas Service Center. Can you throw some light what's going on? There is no light, Kishore. I'm sorry to say it. It's all dark there. It's completely dark there in Texas Service Center, though. Obviously, right now, given a chance how the things are going on, though, if I were your lawyer, I would have filed an I-140 first, get a receipt notice. Based on that, I would file the 485 application, though. That's all I can do, though. But right now, since it's gone in the dark, there's nothing I can do. My great grandmother used to tell a story that if you lose a ring in the dark, don't search in the light. Go back to the dark and search it there itself. And that's where you are in Texas. That's all dark there, and you are in the light right now. We can't go to the darkness there.
Anat says, my current H-1B max out date is May 27th of this year, and my I-140 was just approved on March 15th. If the H-1B extension is filed in normal processing, can I stay beyond the max out date? So assuming that your final action date is not current, yes, you can file the H-1B extension requesting 3 years based on the fact that you have that approved I-140, and you can stay as long as the application is pending. You can work for up to 240 days based on the pending application. But I would urge you not to mess with it, because I have a feeling your driver's license is probably expiring May 27th, and you might not be able to renew it without the H-1B approval. And what if your H-1B extension gets denied after your I-94 has expired? It's much more difficult to get back into H-1B status if the denial happens after your I-94 expired. So not a good plan. Go ahead and do the H-1B extension in premium processing. Get the decision before May 27th.
Ritesh Bansal has this question, though. I have an appointment. The appointments are very scarce for the Dropbox of H-1B. Any suggestion or recommendations from our team? Okay, guys, just listen carefully. I will tell you something, but this is not coming. I'm not suggesting you to do it. I'm not recommending to do it. I'm just telling what the other people are doing, though. They're making all the things, paying the money, and then they're contacting these agents that are using the username and passwords. I don't know, they keep checking, and they are able to make appointments much better than what other people are making. I'm not suggesting, I'm not recommending, that's what some people are doing. I'm not endorsing either. I'm just telling what those people are doing to get the appointments faster.
Sen says, my GC EAD expedite request was denied, saying the loss of the job does not constitute financial crisis. Can you suggest any remedy? Can I do the expedite again or approach a congressman? How can a loss of job not constitute financial crisis? Totally agree with you on that, but that is how they've been doing this for at least 2 years now. We had the same issue when people were losing their jobs because of the delays in the H-4 EAD renewals. Same thing with L2 EAD renewals, which at least that's been taken care of by the lawsuit. But yeah, you can try and expedite again, but you're likely to get the same result. Congressman's office is not doing anything because they say it's within the normal processing time. Litigation, if your EAD application has been pending for 6 months, that may be a good option.
Neuron has this question: is it okay to apply for naturalization 4 years and 9 months, or you have to wait for exactly 5 years? Good question. You can apply 90 days before your 5 years, not exactly 4 years and 9 months, because I want you to be very careful, Mr. Neuron, because it's 90 days before. I normally recommend 85 days, because if you do it on 91 day, they will take your money, they will call you for interview after 1.5 years, and they will say, you applied 1 day before, we are going to deny the naturalization. Believe me, it happened. So I would recommend 85 days. And you're right, you do not have to wait for 5 years. 85 days before your 5 years, you can file it.
Srikar got the receipt number starting with IOE for an I-129 petition that was filed with the Vermont Service Center. Can the I-129 actually be e-filed? That IOE generally is issued for e-filed applications, but no, I-129s cannot currently be e-filed, but USCIS is issuing the receipt notices with that IOE because they're able to, it's a new program, they're digitizing or making it electronic after you file it on paper, and so those are given with the IOE, but your application is actually pending at the service center listed at the bottom of the receipt notice.
Question that gets repeated again: what do you say? Refiling is better if my application is in Texas Service Center. In our office, there are so many different opinions, ourselves too. My colleague Vanita was asking today, why are these people wanting to refile? I said, the applications that were filed on or after October 2021 have more approvals than the applications filed in October of 2020, and that's the reason why. So it's a judgment call to be made. The main minus point that you have in refiling is that you will have to wait for next 180 days before you move out of this company. And of course, money is definitely a part, because you will have to pay the legal fees and the filing fees again if you want to refile. So those are to be taken. Yes, you have a good probability of going in 2 lines and good probability of getting into National Benefit Center.
RK from YouTube wants to know, can we travel outside while the I-140 is in process? Yes, you can. No issues at all. The I-140 does not require you to be in the U.S. at the time of filing or while it's pending. You don't have to submit any immigration documents with your I-140. All it requires is the labor certification, proof that you qualify for the job, so that would be your education documents and experience letters, and proof that the company has the ability to pay.
Jenny Afreen has this question. Please share the impact of filing I-485, new I-485J within 180 days of the 485 pending though. I'm assuming that you have moved from company A to company B. One thing though, I will not file the I-485J supplement until after 180 days though. Even though you left the job, which I would recommend not to, but you are forced to leave the job or whatever circumstances though. There are a lot of arguments that can be made if you don't file the I-485J though. So you're working with company A, let's say you lost the job at 150 days. I would not file the 485J immediately. I will wait for some more time to file the I-485J. I will not do it immediately, because you are inviting the immigration officer to deny your application by filing it. That's a great invitation for them to deny the application. I would file it after 180 days. If necessary, I would argue that, hey, even though I may have left the company A, the company A never withdraw the offer until after 180 days. So I'm still eligible for getting the 485 application. So I will not give an invitation to the immigration officer to deny my client's application.
Nyan says, I'm on H-1B and applied for my wife's H-4. Is she eligible for the H-4 EAD? My perm is still in process. I-140 is not approved. So in most cases, the I-140 approval is what makes your wife eligible for the H-4 EAD. There's a limited situation where if you used your pending perm to get an extension of your H-1B beyond the 6-year limit, then she can also be eligible for the H-4 EAD. But if you're in your first 6 years of H-1B and no I-140 is approved, she has to wait until you get your perm and I-140 approved.
Carlos has this question: what is the approval rate of EB2 NAW? Is it still worth applying in 2020-2023? If you have, these are the things, the qualifications are more important. If you qualify for the EB2 NAW, definitely you should apply for NAW though. Especially if your employer is not applying you in the perm application though, I would definitely will evaluate to see if it's worth filing now. If you just have a computer degree and then you're just a simple software developer, nothing special, nothing odd about you though, I would not even entertain filing NAW. But if you qualify for those requirements, then you should. The lawyer in our office who does this mostly is Rebecca Chen. You may want to consult her. You can go to RN Law Group website, make an appointment, and make sure that you give your resume, and especially if you have any scholarly articles, you can point it out to her. She normally goes and checks in the Google Scholar articles to see if she's there, but if there is anything else that is extraordinary, that is outstanding, you should try to point it out to her so it will become easy for her to evaluate your case. Arush has this question: can I interfile from EB3 to EB2 when I'm outside USA? I'm assuming that you already filed the 485. Absolutely, you can interfile while you're outside the country.
Jigar wants to know, if the 485 is not approved and the H-1B is expiring, is it better to stay on the EAD and AP or extend to the H-1B? You definitely have the option here, especially assuming your I-140 has been approved. In that situation, with most employment-based 485s, there's not a lot that goes wrong. It's relatively safe for you to forego the H-1B and instead use the EAD AP. With that option, you have the benefit of getting the 180-day auto extension for those renewals, and you're avoiding the legal fees and filing fees and premium processing fees and everything involved with an H-1B extension. And if your spouse is on H-4 and H-4 EAD, all of those delays, you get rid of those by sticking with the EAD and AP instead of continuing on the H-1B status. A lot of people like to keep the H-1B because it's a kind of a backup plan in case something goes wrong with the 485 or in case the EAD renewal gets delayed. That's not a bad thing, but it may be unnecessary in a lot of situations.
Suhas is asking, what are the timelines of September 2015 priority date to be current in EB2? If USCIS or if the State Department is from this planet Earth, the priority date should be 2016 or maybe even 2017. But they don't look to be from Mars, they don't look to be from Earth, they look to be from Mars or probably or Venus, maybe Jupiter, maybe from some other solar system though, because they don't even look to be from Mars and Venus to me. The reason is that if you look into their own stats though, in December 31st of 2021, they had 250,000 485 applications pending on the employment based. By that time, they only adjudicated the 30,000. In other words, if they finish the entire 250,000 applications though, by the end of this year, that is as of September 30th though, then they would have filled the 280,000 applications though. But then what's going to happen? The processing time of Nebraska Service Center, which the USCIS published, I don't. When they publish the Texas Service Center processing time, they publish it. They are taking that they're going to take approximately 2+ years to adjudicate the 485 application. So if you're going to ask me what should be the priority date, it should be 2016 or 2017. But these people are from Mars or Venus or maybe from a different solar system. We want all of you guys to write letters that we have put a draft there to the congressman, to the administration, to look into and not wasting the green cards. If they don't waste the green card though, your priority date should have been current in April itself. So it depends on whether we can make them come to earth and live on this earth, look into the numbers, what they are publishing, not we. Then we can make the priority date move forward. So it's on you. You are responsible. We have given the draft.
Ms. Wateja wanted to know, I applied for the H-1B visa stamp at the consulate and received a 221G. Employer already responded to it, but it's taking time. Can I now apply for an L2 as a dependent instead of waiting? Yes, you can do that. And the L2, once you enter the U.S., does give you that automatic employment authorization, so you technically don't need the H-1B.
Kanya has this good question from YouTube. My priority date is July 2011, downgraded I-140, pending in the black hole called SRC, also called as Texas Service Center. We interfiled recently. Does I-140 EB3 has to be approved for the green card to be approved? It's an interesting question. According to my readings, Emily, I want your attention to that. The EB3 is pending, I-140 is not approved, final action date is current in both, file the interfiling, can they approve the green card? My reading is that they should approve the EB3 also, because the interfiling was being done recently. The 485 has been pending, the fundamentals of the 485 is based on the I-140 that was filed in probably October of 2020. So that I-140 is still not approved, so the base is not established, but I could go wrong.
Mm-hmm. Yeah, I think that's an interesting question. And I do think that they need to see that you are eligible to receive the EB3 green card, and now you're asking to instead receive it in EB2. And that eligibility isn't there yet because you don't have that I-140 approved.
Yeah, eligible to be filed actually, to be eligible for the 485. Yeah, because that establishes only when the I-140 is approved. So.
Deep says, I received an RFE for my H1 extension, haven't responded yet. Priority date is current in EB2, haven't received my EAD or AP. What are my options to continue to work if the H1B gets denied? I think it depends on whether your I-94 has expired from your H-1B extension, which is why I recommend filing early and filing it in premium, so that you get a decision before your I-94 expires. In that situation, your H-1B can be refiled. You could file a transfer, you could file a change of status to another type of visa if you qualify for it. But if your I-94 has already expired, then your option is to file an H-1B appeal, have your employer file that, and you have to sit and wait until that gets approved before you can work. And while you're waiting for it, you stay in adjustment of status based on your pending 485, but you have no work authorization until you receive the EAD or eventually get that appeal approved.
Anything else, Emily?
I think we are out of time for today. Thanks so much for joining us. Remember, you can track the 485 filings that are coming from Rahul's desk by going to immigrationgirl.com, and you can join our newsletter by going to rnlawgroup.com.
Don't forget that we do have a daily free conference call, and the link is provided at there, that every day at half an hour is spent. We also want to thank all of you guys to come, and it is an education for us too. There is a lot of improvement that we get by listening to you, by reading your questions, by able to answer these questions. It sharpens our skills, and without you guys feeding all these questions, so we wouldn't have been there where we are. We're very thankful for coming and asking us a question. That educates us a lot and also keeps us sharp and get to know what your feelings are much more than we sitting in office and just doing our work without listening to what you have to say. Thank you very much.